Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning and welcome to our firm's virtual First Friday event and 2000 Virtual HOA Condo Academy class number 12. We've just put up on the screen a poll because we always like to know who's here, and we also want to know what your role is in the community. Well, first, let me just start out while you guys are working on your poll results and start out by saying Merry Christmas, Happy Hanukkah, and Happy Holidays to everybody. So glad that you could be here for our last live broadcast of this year. For those of you who may not know me, my name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. I've represented HOAs and condominiums in Arizona for the past 28 years. Can't believe it. My firm currently represents over 1,000 planned communities and condominiums throughout the state of Arizona. I also currently serve on my HOA board, and I have for many years. Today's live virtual First Friday event is held in conjunction today with class number 12 of the 2024 Virtual HOA Condo Academy. And this is our firm's final virtual session of this year. First, I just would like to extend a big thank you to the cities of Avondale, Chandler, Goodyear, Glendale, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for your continued partnership regarding these virtual HOA Academy classes and the series that we put together. Thank you for caring about your residents. Thank you for providing them with opportunities for free education so that they can have better managed communities and better run HOAs and condominiums. And thank you for your continued support of these virtual classes. Now we are at the phase where we're going to be talking about what our poll results are. So let's get right into those. And the question in terms of in which city do you reside, we have, had 79 people respond, which is awesome. And the responses are Avondale is 2%, Chandler 16%, Glendale 2%, Goodyear 4%, Mesa 10%. So that is amazing. Also, which your role with the association, we have 84% of you here today. 43 people are on the board of directors. 8% are managers, which is amazing. Thank you so much for being here. And let me get back to my balance here. Let's see. We have 6% are interested homeowners and 2% are other. So great representative today of all the different people that are here today. So wonderful. Okay, just a quick friendly reminder, due to the large volume of questions that we receive, this free opportunity is limited to one question per association. So if you plan on submitting a question live during this session today, please do so at this time. And also include the name of your HOA or condo and your current role when you submit your question. Thank you so much for understanding. And we're so happy to have you here today. Okay, let's first start out by talking a little bit about the Corporate Transparency Act. For those of you who are subscribed to be on our Mulcahy memo list, which is free, if you haven't done that, I really highly recommend that you do that. All you need to do is send me an email saying, hey, can you add me to your mailing list? We put out a communication late on, I think it was Monday night or Tuesday night, maybe, as soon as the court ruling in Texas was issued regarding the Corporate Transparency Act. So I want to talk a little bit about that at the beginning of this session today, because it's a really hot topic in our industry right now. Okay, so on December 3rd, 2024, a federal judge in the Eastern District of Texas issued a nationwide injunction against the enforcement of the Corporate Transparency Act. Now, let's keep it in perspective. This ruling occurred in Texas, but it may have broader implications. The court order claims to suspend the January 1, 2025 deadline for filing a beneficial ownership information reports nationwide. And so it appears to have a nationwide stay on the requirement to file those BOI reports to comply with the Corporate Transparency Act. However, kind of an interesting analysis on this is Arizona is the Ninth Circuit Court of Appeals, while Texas is in the Fifth Circuit. And so for those of us who are closely monitoring all of these cases, it's 3-2 if you're a numbers person. So we've had 3 cases that have said that the CTA is constitutional, 2 that say, in a preliminary injunction hearing that they feel it's potentially unconstitutional. However, this most recent case in Texas is put a nationwide stay or hold on people filing the BOI reports under the Corporate Transparency Act. So this Texas court took it a little further than, the other court that ruled that this was potentially unconstitutional. So what do we do? It's kind of a quandary, right? It's important to note that the precise nature of this ruling, as it was explained by the National Law Review, is that the court has determined that the CTA reporting rule are likely unconstitutional for the purposes of a preliminary injunction. It has not made an affirmative finding that the CTA and the reporting rule are contrary to law and they amount to a violation of the Constitution. This is just like a pre-ruling in the case. So what are some key points for us to consider as we navigate this issue? Well, first, we are closely monitoring how this Texas ruling might impact the CTA filings in Arizona for HOAs and condominiums. Remember that this injunction is just temporary, and the legal situation on this could evolve rapidly, meaning that it's very possible that there could be an appeal filed that would change this situation to make it so that we still have to comply with the BOI by filing the BOI by December 31st. So it's a rapidly evolving situation, is what I would like to say. And we need to be on our toes between now and December 31st. At this time, we are still recommending being ready to file the original CTA reporting requirements. And by that, I just want to explain that this is kind of a gray area. And so although there is a nationwide stay, according to this case, if there is an appeal and the court lifts that stay in the appeal, all of us will need to file those BOI reports by December 31st. And if that should happen, it's going to be very difficult to get all those reports filed on time because it's a timely process to file those, number one. And then number two, the system has already been glitching. The federal government system through PHMSA has already been glitching earlier this week before this case was decided. And the system, in our opinion, was potentially already on overload before the case was decided this week. So, there's kind of lots to think about in terms of how should we handle this as a group? Should we go ahead and file these reports? Our firm is leaning towards doing that if we already have all the information and it's just a matter of filing it. But it's really up to your association as to what you want to do. I have some clients that are saying, no, we never wanted to comply with this to begin with. And therefore, we're willing to take a chance and wait and see what the court may do on this particular issue. Okay. If you're interested in reading more detailed analysis of this ruling, we encourage you to read the full article in the National Law Review. And we're going to be sharing that link here. And also, you're welcome to read Bloomberg's law article, also, which we're going to be linking here on Zoom and Facebook Live. As always, we will be on top of this and we'll provide an update as soon as we have more information. In the meantime, we recommend continuing your preparations for the Corporate Transparency Act compliance while we seek clarification on how this rule may specifically affect Arizona or while we wait for any appellate actions that may be regarding this Texas case. Just so you know, as of this morning at 8:40 a.m., an appeal has been filed by the federal government, and several sources suggest that an expedited appeal is likely. And so, like I said, we need to be ready for this, and everybody needs to be on their toes because we're going to need to act quickly if the federal government does issue a ruling saying that the BOI reports need to be filed by December 31st. One more thing, just remember, please try to make sure to be subscribed to our Mulcahy memos. We push out information quickly on emerging law and developments that are important for you to know about. And so the best way to sign up for it is to email me at info@mulcahylawfirm.com to ask to be signed up for it. And we'll make sure that you're added to our list. It's free. And we usually send out 1 or 2 memos a week on different topics. And now more than ever, it's important that you be informed about what's going on with this Corporate Transparency Act. Okay, a quick reminder about holidays. It's been so busy with the Corporate Transparency Act, it's been kind of hard to think about celebrating holidays this week. And a couple of things. We don't want you to end up on the evening news or in the media for being unreasonable in the holidays. whether it has to do with decorations or holidays or visitor parking. Remember, keep everyone safe and promote community spirit. The holidays are a great time for everybody to have a great experience in your community and to get along. And if you have an issue with an owner, maybe about overzealous Christmas decorations, give them a call, talk to them a little bit about it, and see if you can resolve it so that something doesn't get pushed, into being on the news in Arizona or a negative news story about your association. Okay, let's get right over to our Q&A session. We have 95 people here today, which is amazing on Zoom. So thanks so much, everybody, for being here today. I'm fighting a little bit of a cold, so I'm sorry if I'm not my voice isn't as strong as it usually is. But we are muscling through today because we have a lot of questions. Let's see our total number of questions. I'm just going to do a quick check so I can kind of get an idea of how many questions we have today. Right now, we have 38 questions, which is a great turnout. So let's start with our first question today, which is from a board member. Our management company is now going to charge $50 per month fee if an HOA wants to do business with an investment company other than their associated bank. I would like to know if this is legal. It's kind of hard for me to comment on this because I don't know enough about how this is working. I mean, is this like a fee, that credit card fee, if you guys have to pay by a credit card? I mean, at first glance, it seems like it's not a very customer-friendly approach. I don't know from a legal perspective. I mean, you'd probably have to agree to it if you want to make the payment this way. So you'd probably be clicking, I agree to this fee. It does seem excessive, and it doesn't seem like it's something that I would be supporting if I were your association's attorney. Usually if you're making a payment to the association, it should be at no charge. So I'd want to find out more about that. But at first glance, it doesn't sound like a good idea. Okay, next question from a board member. Last month, I asked about the board secretary's responsibility to set board meeting agendas per House Bill 2662. The bill provides that the secretary of the association is required to provide an agenda in advance. I attempted to do this and got ignored. I believe our association is interpreting the language of the new law to the advantage of the management company, and in doing so, violated the intent of the bill and prevented the secretary or treasurer from following the law. This is kind of upsetting to hear, honestly. House Bill 2662 does require that the agenda be provided to all owners 48 hours in advance of the meeting. And it's such a basic law. There should be no question as to how this is applied, et cetera. And so I don't know why they didn't agree with this, but what I would recommend is that you document your concerns in writing as a board and tell the management company works for you. Tell the management company that, they need to comply with the law. And you're welcome to share this video if you need to support that position. Okay. We also are going to be sharing with you a chartered version of the new law. So if you want to share that with the management company, you're welcome to. Okay. Next question is from a board member. Regarding the Corporate Transparency Act, is your contract to complete the paperwork for the individual HOA or for the management company that works for the HOA who will act on behalf of all their clients? So really good question. So we are just working with the boards. We never represent the management companies ever. We are totally independent from all management companies, and our client is always the board and the association. And so I do know that some management companies are saying to their associations that they manage, we want you to use our attorney to do this. It's the board's choice who they want to use. And we really do recommend that you have separate legal counsel from your management company. Okay, question number 4 from a resident. Our community records all board and committee meetings. How long do we have to keep these recordings, and how long are they required to be available to the property owners? So if you're recording them, I would keep them for at least 6 years, maybe 7 years to be safe. And why? Because if anyone challenges this under the law, there's a 6-year statute of limitations for breach of contract. Okay. Question. And because you're choosing to, record the meetings, and potentially, I guess you're maybe not letting the owners record the meetings too. If the owners want to request a copy of the meetings that were the audio version, you would need to provide that to them. Now, remember, the minutes are always going to be the official record of your association's board meetings. Okay. I have heard conflicting information from various different people. Does ARS 33-1818, a right to regulate a public roadway vote, apply to only parking? Or does it include the planned community's right to regulate garbage bins being out more than one day, portable basketball hoops in the road, etc.? That's a really good question. I'm going to have my office cut and paste the statute in there, put it at the end and cut and paste the statute in there so that I can take a closer look at the language. And we'll come back to this question at the end. Okay, next question. We just came under full management with a new company. The management company claims they have to send monthly statements to all owners based upon the summary provided under Arizona law. We understand it to say only for HOAs over 50 units or not managed by a third party, and only for delinquent accounts, of which we have none. This management company states the opposite. They have to send the monthly statements to all owners if managed by a third party. What is your interpretation? I'm going to have my firm do the same thing. Let's pull that statute quickly, and I can take a look at it at the end. But I think you probably are going to have to comply with that because you are managed by a management company. But let's look at it a little closely at the end. Okay, next question from a board. The new law in September requires the agenda to be mailed out 48 hours in advance of a meeting to all members. How does this affect amending the agenda at the meeting? And can you still amend the agenda at the board meeting? The president makes the agenda, but how should the president arrive at which agenda item should be on the agenda? Should the other directors request for items to be put on the agenda? Or can the president by themselves reject a director's request? Okay. So agendas, lots of questions on agendas since the new law was passed. It does need to be provided, the agenda needs to be provided 48 hours in advance of the board meeting. And so that should just be standard practice now for all associations. How does this affect amending the agenda at the meeting? There's always going to be items that need to be added to the agenda at the meeting. So don't get caught up on, it wasn't specifically on the agenda. You can put things under new business or old business if it's an old business issue. Things come up at the last minute. So don't play the agenda game. Well, it wasn't on the agenda, so we can't talk about it. Now, on that same note, don't play the game of the I'm not going to put it on the agenda and surprise everybody, because that's not a good thing at all. So just be reasonable as you make these determinations. So let's see, the president makes the agenda, but how should the president arrive at which agenda item should be on the agenda? Ultimately, the president does make the agenda for the association. Okay, we all agree that. Be reasonable. Don't shut anybody out of the process. If you're the president, if somebody on the board wants to have something placed on the agenda, be reasonable and let them, have that on the agenda. Okay, question number 8 from a board member. The board asked an individual to serve on the board to fill the unexpired term of a board member who resigned. Our bylaws specifically state that board members must be owners. This individual filed a quitclaim deed in 2009 to transfer the property to his wife as her sole and separate property. Should this person be asked to resign from the board, or how is this handled? I think what I would want to do is talk to the board member about this, and say, listen, our bylaws require you to be a unit owner. We do not have a deed showing that you are currently a unit owner because your wife is listed as a sole and separate property owner. Are we missing something? Has there been an amendment? And if not, make sure you tell that person that unfortunately our appointment is invalid because you're not an owner. Now, in some cases, what they will do is an association will, owner will decide to just deed 1% interest or something in the property so that they can stay on the board. So we have seen that happen in the past. So that may be something that could happen that would allow that person to remain on the board. Okay, next question. Number 9. ARS 33-1804 states, any quorum of the board of directors that meets informally to discuss association business, including workshops, shall comply with the open meeting and notice provisions of this section without regard to whether the board votes or takes any action on any matter at that informal meeting. Does that mean that town halls must comply with all open meeting requirements if a quorum of the board members are participating? So they must give 48 hours notice. They must have an agenda. They must have minutes. So the short answer would be yes. Even if it's an informal meeting, like a town hall meeting, you still need to fully comply with the open meeting law. What are the rules for town halls with less than a quorum? If it's less than a quorum, then, it's not an open board meeting. Okay, next question. What information is required in paragraph 3 of the BOIR report for the Corporate Transparency Act? I'm going to have my firm pull that up, and then we'll answer that question at the end because I don't have that form right in front of me. Okay, number 11. From a board member, our president has been reminded since October that meeting notices and agendas must be posted at the same time. It's so crazy. We're getting so many questions today on the agenda. She ignores the other members of the board, meaning the president ignores the other members of the board on this agenda. The president puts the meeting notice in the elevator and figures she has met the open meeting requirements. The president does not notify owners through email or meetings or send Zoom notices to individuals that they may be away. What are the proper procedures for an HOA meeting? Okay, a couple things. Meeting notices and agendas should be provided to the owners 48 hours in advance of the meeting through any reasonable means. So it sounds like your president isn't doing that with the agenda and needs to start doing that. Just putting the meeting notice in the elevator without the agenda is not fully complying with the law, but just posting the meeting notice with the agenda in the elevator in the future would be complying with the law. I know it sounds strange that you have people that live off site, and they may not be able to see that notice because they're living off site, but that does comply with the law as long as the notice and the agenda are there. I would recommend as a best practices that you also email it out to everybody so that anybody who wants to attend would have the ability to attend, and give them the link. I don't like it when associations say, if you want to attend our meeting on Zoom, reach out to the manager to get the Zoom link. I mean, that's just kind of like an extra hassle for people. Just put the Zoom information right in the notice. Okay, what as a community, let's see, what are the proper procedures for an HOA meeting? I think we kind of just went through that. We also have some great cheat sheets on this topic entitled Board Meetings and How to Have an Efficient Board Meeting on our website at mulcahylawfirm.com if you'd like more information. Okay, question number 12 from a board. We have an owner member who has been harassing other HOA members, ARC members, and board members through emails, verbal communication, verbal conversations, watching others walk by their driveway using a video camera, and going out there to meet them as they go on a walk in the community, trespassing on other members' property, and taking unsolicited maintenance actions on community property, like on our gate and keypad. What can we do as a board to stop this behavior? I really recommend that you have our firm or your attorney send this owner a letter just outlining the problematic behavior and asking them to cease and desist. Okay, question number 13 from a manager. If a board member is not able to attend a meeting which would cause a quorum to not be met on a two-person board, can their spouse or other family member on the deed attend on their behalf, or does that meeting need to be rescheduled? The meeting needs to be rescheduled because you can't give a proxy vote to another owner under Arizona law or as a board member. Okay, question number 14 from an owner. There is an abandoned vehicle with a for sale sign that has been parked in one of our visitor parking lots, common areas, that belongs to an owner in the community since April 2024. Our CC&Rs state any vehicles parked on the property must be in working order and have current tags. The registration tags are over 3 years expired, and the tires are going flat. I've made 5 written complaints to the management company directing the community manager to the unit owners whose vehicle is parked there. We have no towing provision in our CC&Rs. What recourse do I have as an owner or a resident? A couple things. You could write a letter to the board to document your concerns. I think that would be a good idea so that they know that you're not going to let this go and you're serious about this issue. The second thing I would do is I would consider, if it's not resolved amicably, to go to the ADRE, the Arizona Department of Real Estate, and file a complaint against the association for not enforcing their documents. You could hire an attorney to write a letter on your behalf, or you could file a lawsuit. I doubt that this is serious enough to file a lawsuit, but those are all some really good remedies. I encourage you to look at our enforcement cheat sheet on our website at mulcahylawfirm.com to give you some other ideas and more details on how enforcement procedures and the association should be working. Okay, question number 15. How much money is an Arizona self-managed HOA required to keep in their reserve fund? That's a really tough question to answer because I don't know much about your amenities, but the best advice I could give you is take a look at our reserve fund cheat sheet that we have that kind of outlines what is a reserve and how is it funded. A quick short answer would be that you should hire a reserve specialist to give you a reserve study, and they can give you the exact amount that you should be having in your reserve at this time. Okay, question number 16. We are looking for ways to have our property management company be more responsive and accountable for following up on items. What are appropriate ways to do this? I would really recommend that you take a look at our videos that we've taught recently. You can find them on our website at mulcahylawfirm.com under our helpful videos section. Anyone that deals with effectively working with a management company, that's going to give you a really good deep dive on what are some strategies for handling problems with management companies. But just very quickly, I think what you need to do is have a meeting with your manager, outline your expectations, and give them deliverables that they need to be following. If they don't do that, go higher up in the organization and, talk to the head of the company and see if they can get that person to do what they're supposed to be doing, or maybe get a new manager. If that doesn't work, then you may want to consider looking into hiring a new management company. Okay, next question from a board. ARS 33-1807 provides for a general lien for delinquent dues. What is the purpose or benefit of recording a lien? One of our properties is scheduled for a trustee sale in early January. Should a lien be recorded, the balance is over $13,000. So probably just to be safe, I would put a lien on the property, only because, well, here's what I would say. If you contact our office, we can do a quick check to see if, there's equity in the property. Because if there's equity in the property, it's really equity in the property, meaning that, let's say that the property is worth $300,000 and they only have a mortgage or a deed of trust on the property of like $150,000 or $100,000. So there's like over $100,000 in equity in the property. If that's the case, you definitely want to put a lien on the property, because we want it to be established that we have lien priority at the trustee sale. Because what will happen is, typically if there's equity, a third party will come in and buy the property at the trustee sale. And then we'll be first in line with our recorded lien to make a claim on that extra money that's paid. Usually there's like a bidding war when there's excess funds generated because the property has a lot of equity. So short answer would be yes. I think it's a good idea for you to record a lien as long as there's equity in the property. If the property is underwater, I wouldn't waste the money recording a lien. Okay, next question is number 18. Is there a 2025 law regarding the number of full-time residents, allowed in a mobile home cooperative that also has a few RV spots? I'm not aware. Well, it's 2024, so I don't know what the laws are going to be introduced in the legislative session in January. So maybe I'm assuming that you mean a 2024 law for full-time residents in a mobile home cooperative. There are special laws that pertain to mobile homes that are different from HOAs and condos. So honestly, I really don't know the answer on that. But if you reach out to our firm, I can give you the name of an attorney that I know that specializes in working with RVs and motorhomes and motorhome cooperative. Or you can email me at info@Mulcahy Law Firm, and we'll just pop you an email right back with that information. Okay, question number 19 from an owner. My board often takes action on HOA business via email, ignoring any aspect of the open meeting law. I have requested documents related to these actions, and I'm told that it is a privileged board member information and not available to community members. How is this legal? What can I do? The Arizona Board of Real Estate route is expensive and does not appear at all to be effective in reining in control of boards. Actually, I really disagree with that. I do think that the Arizona Department of Real Estate, that the rulings that are issued by the administrative law judges in these cases are very effective in getting boards to comply with the open meeting law. So I disagree with that. One thing I will say is I think you probably need to hire an attorney to write them a letter to get the records, because these are not privileged records as they're indicating. You should be entitled to see them. And keep in the back pocket the ADRE and a potential lawsuit if this behavior continues. Okay, next question, number 20. Which of the legislative committees in the Arizona House and Senate oversee HOA state statute matters? I'm interested in seeking sponsorship of a bill in the 2025 legislative session concerning CC&Rs and the need to know which committees are most relevant to HOA and condo association statute changes. Okay, what I would recommend here is I would recommend to you that you get to know your legislator in the House and the Senate in Arizona, because that's the path that you have to introduce new bills. And so that would be what I would recommend. There's all different kinds of committees that look at the HOA bills and condo bills each year. And going to a committee directly probably is not the right way to do this. You may also want to talk to the Community Associations Institute if you're a member, and they might be able to help you with introducing a bill. Okay, next question, number 21. Do homeowners have the right to see violation reports in their entirety? If not, which type of violation reports are they able to review? Well, they'd be able to see a list of the violations in the community. I probably would redact the names and the unit or lot numbers on that if I were the attorney advising the association, but they can see a list of the violations, just not have the personal information of the owner listed on there. Okay, next question. Should homeowners be able to submit agenda items for HOA meeting discussion? So probably not. The time for homeowners to make comments would be during the homeowner forum at the board meetings. And, they normally owners do not put items on the agenda. Okay, question 23. We just sent our 2025 annual dues invoice via email or via US mail. There are 117 homes in our community. Can we email the invoices or even drop them in our owners' mailboxes next year? Are there certain things that we need to use the US Postal Service for instead of email? So great question. Okay, a couple things that you have to use US mail for in an association. You have to use it for like your notices of annual meetings of the membership or special meetings of the membership. So anytime you're like voting on an assessment increase or you're electing directors, that is going to have to be something that you should send by US mail or hand deliver is what the law says. The 2025 annual dues invoice, that does need to go by US mail unless owners opt in to do it by email. So you may want to engage in an activity where you try to get people to opt in. You could even put that on your annual meeting ballot. Hey, I opt in, yes or no. I opt in to have the annual dues notice sent to me by email instead of by US mail to save money. But those are the way that the laws are written so that people receive these materials and they have to be done by US mail or in person. Okay, next question, number 24. Just how detailed should an open session agenda be? Our town council essentially provides the entire board packet equivalent. We provide the topic with minor details. Homeowners would like to see everything like the town council and not our shortened version as the HOA or condo. A huge majority of the people cannot care less about this. We have over 2,000 homes and we get about 12 attendees for the meetings. What is a good balance or rule of thumb? I agree. This does not have to be as detailed as the town council for sure. What I would say is just have enough detail that people, if they want to tend to hear more about a subject, they have enough information that they would know that this subject's going to be discussed. It doesn't have to be like a deep dive into the subject. It could just be like discussion of bylaw change of number of directors from 7 directors to 5 directors, or discussion of the 2025 budget. That's sufficient. It can be very general like that. New business, old business, all of that is fine. Okay, next question, number 25. I'm just going to do a quick check to see how many total questions we have. So I kind of we have 44 total questions. So we are on number 25. Okay, let's see. From the board, are there any potential tax implications, liability issues, or any other legal concerns to the HOA that are related to food being prepared by our HOA residents in their own homes and sold to our HOA residents through fundraising efforts such as bake sales, pancake breakfasts, potato bake sales, where the proceeds are used to fund special projects in our resort or donated to Christmas charities in the greater community? Specifically, are we responsible as an HOA if someone gets sick from food allergies or food poisoning? I would say probably not. I mean, a lot of associations have these potluck type things, and, people know when you come to a potluck, it's, beware, there might be norovirus or something. Although these instances are very rare. I don't think I've ever had this question for an HOA come up or a condo come up where somebody got food poisoning or norovirus or something like that. I would just say, no, I don't think this is a big deal. If you're worried about this, you could put a notice or something saying that, hey, any food that's consumed is at your own risk, or anything that you buy is you're buying it at your own risk. Okay, next question, number 26. When amending association documents, what constitutes a legal ballot vote on them? So we have a great cheat sheet on amending CC&Rs, a 5-step plan that I would encourage you to take a look at. You can find it on our website at mulcahylawfirm.com. So what constitutes a legal ballot? Well, what I would do if I were preparing the ballot for your association is I would look at the amendment section in your CC&Rs and see what the language is for that. I would comply with the absentee ballot requirements under state law. If an absentee ballot can be used, maybe it's a written consent. So you really need to look at what your documents state and then look at what state law requires for absentee ballots or written consents. Okay, next question, number 27. A property owner in our gated community is wanting to donate his vacant lot to the Paradise Valley Mountain Preserve Trust. How do we ensure HOA regulations, annual dues payment, and restrictions to public area in the closing documents are adhered to? I think probably the best thing you could do is have your attorney take a look at that and give you suggestions. There should probably be like a written agreement so that the trust understands that you're a full owner and you have all the responsibilities of a full owner. Question number 28. How can HOAs address non-responses to violation notices and non-payment of assessments from elderly homeowners, especially when they might be deceased or in managed care facilities? This is a big issue. We see this often where we have a resident who is ill or they go into like a care facility and then all their bills stop being paid. The key thing, a couple of things that we do internally, our office, we try to reach out to the family members to see if we can get this set up like on an auto debit. We try to find out where the owner is and send the notices to the new address in addition to the property address. Sometimes we just have to lien the property if they aren't paying and they aren't responding. So if you're in that situation, make sure you reach out to our firm. We have been successful in helping associations navigate this and get paid and get them on a payment where they start making the payments regularly again. Okay, next question, number 29, is if an association residents submit a request to cut an opening in the building exterior so if a resident asks to cut an opening in the building to install a window, can the association demand that the resident use a licensed and insured contractor to do the work, even though it's not specifically stated in the CC&Rs? So yes, I mean, I know that you are a condominium and familiar with your association. So yes, definitely you should put that in your approval if you're going to allow this. And I think that's a very reasonable request. Okay, question 30. Please describe the rules of conduct for a town hall meeting and how it differs from an open forum, homeowners annual meeting, or a routine board meeting. For example, what are the parameters, if any, for a conversational dialogue with individual homeowners attending the town hall meeting? Okay, so there really are no rules for a town hall meeting. I mean, generally, you're having a town hall meeting when things aren't going well, in my opinion, or you just have been doing it in your association for many years, and it's something that you do just to keep the pulse on things. But from my perspective, most associations don't regularly conduct town halls, although I wish they would. We usually bring out the town hall when there's a problem in the association. And what I recommend to the boards for the town hall meetings is just listen. Listen to the owners. Give them a reasonable period of time so that they can talk about issues, like maybe 2 minutes per person that wants to talk, and listen. Don't feel the need to dominate the meeting as a board. This is your opportunity to listen to the owners. How it's different from an open forum at a homeowners meeting, it's just a longer version of an open forum. The whole meeting is an open forum. So we don't go and do a regular board meeting typically. Or the annual meeting, same thing. I mean, the annual meeting has business, a regular board meeting has business that we have to get through, but a town hall is basically just our opportunity to listen to the owners. Okay, next question, number 31, from a board member. If a condo unit owner rents out their unit and the renter accumulates a significant amount of unpaid citations that the owner has not addressed, can the association prohibit the owner from leasing the unit again after the renter moves out or until the outstanding balance is fully paid? Okay, so we've got a condo, the owner's renting their unit. The renter accumulates a bunch of unpaid citations. So I'm guessing you mean fines. But remember, the fines go to the the fines go to the owner, not to the renter. The owner is responsible for the fines. And the owner in this case apparently is refusing to pay it and hasn't addressed the issues. So can we prohibit that person from leasing the unit again? So a short answer on that would be no. We can't do that until the balance is paid in full. I've never seen a set of CC&Rs that would allow that. And honestly, I wouldn't write anything into the CC&Rs that says that. You could check to see if you can suspend the voting rights of the owner and also the right to use the common areas. That might be an effective way to handle it. But this really seems to me like it's something that maybe you might want to turn over to your attorney to send a letter to the owner landlord to get these issues resolved. Okay, next question. Question number 32. This is a question on the Corporate Transparency Act. Please clarify similar office in the statement, the CTA document in this statement. The CTA generally defines a domestic reporting company as any entity which was created by the filing of a document with the Secretary of State or any similar office of a U.S. state. Our HOA is not a corporation, and to my knowledge, we have not filed anything with the Secretary of State. Our HOAs are recorded with the county recorder's office. So because you're not a corporation, this isn't going to apply to your particular association, so you don't have to comply with the Corporate Transparency Act. Okay, question number 33. This person is a committee member. Casitas Tempe, excuse me. I'm going to go back to that later. I'm sorry, I did not mean to say that. So we'll push that in somewhere else in the class today. Okay, what is a resident's right when it comes to an HOA? Let's see here. What is a resident's right when it comes to an HOA association using video recordings to capture their conversations and movements at the community facilities? So how do residents have any rights if they put up video cameras at the community facilities? So not really. Of course, usually the reason why we put up these cameras, is for security purposes and for if anybody's damaging the common areas, et cetera. And so it's really unusual that somebody would object to that because honestly, it is the reason why we do it is so that we can keep the areas safe and that we can monitor what's going on. And it's a good thing, generally speaking. So if you have any specific reason why you wouldn't want the recordings, I mean, obviously there shouldn't be any cameras in locker rooms or bathrooms or anything like that. But in the common areas, it's a generally accepted and common thing that you see these cameras everywhere now. So what rights do you have? I mean, I suppose if you wanted to have signs put up indicating that this area is being monitored or there are video cameras present, they may or may not be monitored by a person, or you could maybe ask for clarification as to how the cameras are used at a board meeting. Those would be the rights I think that you would have. Okay, question number 35. Every assigned parking spot within our association is numbered except one. The owner of the one unnumbered spot has repeatedly requested to have their spot numbered. The HOA board has agreed to number the unnumbered spot for over a year, yet the spot remains unnumbered. And on several occasions, guests will park in the unnumbered spot, presumably believing the unmarked spot is unassigned. What should the unit owner do? Probably hire an attorney to send a letter to the board. I don't understand. This is a pretty easy thing to do. So the unit owner can document it by writing a letter to the board again, or the unit owner certainly can ask their attorney to write a letter to the board to tell them that this really needs to be done. Question number 36, we have limited parking. We have 2 covered parking spaces that are unassigned. Our board wants to offer them for a monthly fee. 1-year lease to the lucky one that has their name drawn. I'm wondering if this is contrary to our CC&Rs, where unit owners cannot run a business. How can the board run a business? Since this income from the parking is not a budgeted item, how should it be recorded and what should be done with the money? Okay, great question. I think I would probably need to look at the CC&Rs for the association and talk with the board before I could ever give an opinion on this. Don't know. I know many associations do this, and so there is a legal way to do this, of course. If this is an unassigned parking spot and it's a visitor parking spot, are we taking away rights from owners that now they don't have a place for their visitors to park? I think we need to look at it from 360, view and talk about whether or not this is a legal thing that they can do. Okay. Next question, number 37. Rentals in our association are currently allowed. With owner approval, can we limit the number of units that can be rented at any one time? We would like to cap it at 10%. There are 56 units in our association. Happy holidays and thank you for all of your help this year. Oh, that's so nice. Okay, so you want to put in place a rental cap in your association. It's probably going to be pretty difficult to do that for a couple of reasons. Number one, rentals are currently allowed. And so it could be seen as taking away a right if we only allow a certain number of rentals in your community. So you have 56 owners. That means we're only going to have 6 owners will be able to rent. I don't know how many people you have renting right now. So we really would need to look at this carefully. There's a case that was decided a couple of years ago, the Callaway case, that potentially could impact this as well because we'd be changing the use of the property and we may need 100% of the owners to agree to this. So there are lots of pitfalls on this. Also, another thing to mention is that how do we decide who's going to be the 6 owners that get to rent their unit? So lots of roadblocks and problems on this. Hate to be negative Nelly, but this is a tough one. So you may want to give our firm a call. One thing that you might want to do is maybe consider doing an amendment to say no rentals and for future owners or something like that, or grandfathering. And there's possibly a way to do this. It's probably not going to be exactly what you want, but it at least will help you with the problem of maybe managing the rentals a little better. So reach out to our firm if you'd like help on that. Okay, question number 38. What are the rules and guidelines to characterize costs as a capital versus capital improvement versus maintain, repair, and replace? Really great question. So, a good rule of thumb would be look at your reserve fund, right? Your reserve study and your reserve fund, because those are going to be capital improvements. And then you have like your general expenses, which are listed on your budget, which most of the time are not going to be what we call capital items. You usually have a CapEx budget that's separate. Maintain, repair, and replace versus what is considered a capital improvement project. It is kind of a gray area. I'm not going to lie to you on that. Usually the best rule of thumb, I think, would be look at what's in the reserve study. If it's in the reserve study, it's going to be a CapEx item. Next question. Number 39 from a president of an association. We are a small HOA. Can the homeowner vote to run with only 2 board members if we already pay for outside independent bookkeeper? Let's see. So you're saying you have a small association. I think what you're asking is, can the homeowners vote to just operate with just board members, with 2 board members, and not have an independent bookkeeper? It's really up to your board. Your board makes the decisions on these type of things. So, what I would say is talk to the homeowners about it, have a meeting, determine, it's a very small association, so you probably don't need a bookkeeper, but what sort of checks and balances will be in place so that there's no potential for improper actions by the board members. And do the board members have time to do something like this? And are they willing to do something like this? These are all good questions. And since you're such a small association, you should just have a meeting and talk this through. Okay, question number 40. Our reserve is funded by about 2/3 of the budget. Operation then is 1/3. The reserve is on track per the 2023 study and is 91% funded. There are upcoming huge maintenance projects. Homeowners are upset that dues are increasing and reserves are too heavily invested. Are the reserves unreasonable, or can some monies be used for operating expenses? Well, a couple key things. I haven't seen your reserve study and I don't know what your upcoming huge maintenance projects are, but if the huge maintenance projects are going to significantly deplete the reserve, then yes, you don't want to underfund the reserve because it's just going to continue to be depleted as you do these big projects. So some owners want to know, can we shift money from the reserve and pay operating expenses? It's not a good business idea to do that. It's actually poor business judgment and potentially a breach of your fiduciary responsibilities. So we usually don't do that unless it's an emergency situation, and then we pay it back within the same fiscal year. Okay, question number 41. Let's see. If our CC&Rs state that the board president signs all contracts, if someone other than the president signs a contract, is this a legal and binding contract? So great question. Probably yes. Even though your CC&Rs require it to be signed by the president, if the vice president or the treasurer signs it, they probably look like they have apparent authority, and it probably is a binding contract. So best practices, of course, would be for the president to sign everything if your bylaws require that. But on the flip side, if you don't have the president sign it, it's not like a way you can get out of a contract, because typically they're going to look like they have apparent authority, and whoever they sign the contract with is going to be able to enforce that contract. Okay, question number 42. Our prior board and management company cannot provide evidence that they took action when notified 90 days in advance of an insurance increase, taking the HOA over $10,000 in our budget. Further, they took no action on excessive water bills and leak complaints, leading to a $4,000 budget overage. We're a small association and wondering what, if any, recourse we have. If none, how do we cover these overages? Okay, so good question. So it's the board's perception that, okay, we got a renewal notice 90 days in advance from our insurance company that our premium was going to go up by $10,000, or was $10,000 over what we budgeted for. And there was a leak that caused $4,000 water overage charges. So what are our remedies here? Well, first of all, the treasurer should be looking at that water bill line item on the budget every month. Every time the new bill comes in, if it's out of whack for the time of year, some thought should be given that, hey, this is potentially a leak and we need to look into it. So, yes, the management company should be on top of it and should be bringing it to the board's attention. But the bottom line is, the insurance company raised the rates. That's not the management company's fault. Did they not timely tell you about it? Then I think you should be talking with them about, hey, we need to be notified of these type of things a lot sooner so that we can pivot quicker. What kind of recourse do we have? In my opinion, you probably don't have any good recourse against the management company. Maybe if this is a recurrent issue, you may want to think about getting rid of them and hiring a new one. How do we cover these charges? I think you need to look at the budget very carefully. You're probably going to have to do a budget cut on something else. Or, if you have the right to do this under your documents, you may need to do a special assessment to cover that $14,000. That may require a homeowner vote. I don't know. I don't have your documents. So, you have remedies. They're not good remedies. Unfortunately, I wish I could just make it really easy for you, but reach out to our firm. We're happy to help you if you have any questions on this. Okay, next question, number 43. If the board meets with the association attorney, is that an executive session? So short answer, yes. You need to notice that meeting and provide an agenda 48 hours in advance that this is an executive session. Do all executive sessions need to be announced? Yes, you need to do a notice of the meeting, and you also have to have an agenda for all executive sessions. And you also need to cite which section in the law for executive sessions that you will be discussing during the executive session. Okay, question number 44. Looks like we have gone up in questions a little bit. Now we're up to 52. Okay, so question 44 from a committee member. I'm a landscaping committee member. Can my HOA continue to refuse to hire landscaping even though it's on the planned budget for this year and next? They let our insurance lapse, and then they had a very hard time finding a policy, which now costs 3 times the amount. So that is where all the money is going. The board says we have no money for landscaping. This place is falling apart. Everything is dying, and we're spending more money on tree removals. Okay, a couple things. A very common thing that we're hearing from associations is that our insurance is tripling in costs. We're hearing this a lot from associations. There are a few companies that are still providing reasonable rates, one in particular that I'm aware of. So if your association falls in that category, you may want to reach out to me at info@mulcahylawfirm.com. I can share that name with your association of the insurance company that's providing reasonable rates for condominiums and planned communities and townhomes. Ultimately, I know you're on the landscaping committee, but you're not a board member. Ultimately, the board does make these decisions. It does appear to me that things are not going well. They should be maintaining the landscaping. Maybe you need to do an increase in the assessments to cover this. But, the board probably is not acting. I don't have all the facts, but to me, to not do any landscaping and things are falling apart, that's probably a sign that they're not living up to their fiduciary responsibility to the association. So I think some analysis needs to be done on how we can move forward to make sure that this place is being run in a better manner going forward. Question number 45. When and how can board members share background information on a subject that will be discussed at a board meeting between each other outside of a meeting so we all have the same information when we come to the meeting? For example, background information, reviews, costs and expenses, and location, etc., about a new management company. We have several Zoom meetings a year with members in different states. It's hard to have one-on-one, face-to-face sharing of info. So the best way to do it is to have less than a quorum meeting to discuss. If you have less than a quorum, it's not a violation of the open meeting law. Okay, question number 46. Our HOA issues one share of stock to owners. Is it really important for the HOA to issue a paper stock certificate and also to keep a file or ledger naming the stockholders? We never use this stock certificate for anything. So most associations have gotten away from the stock certificates. Those were mainly the associations that were created in the 60s and the 70s. I don't think it's probably necessary going forward, but you do have to keep an owner's list, like an owner's roster under the Nonprofit Corporation Act. Actually, you should be doing this. Okay, next question. We are trying to get let's see. Next question is, notwithstanding restrictions in an association's governing documents, are there state laws addressing term limits for directors and HOAs? We are a condominium. Our documents limit terms to no more than 3 consecutive 3-year terms, and we may want to eliminate that restriction. There are no state laws addressing term limits in Arizona. And if you want to remove that section in your documents, you're going to have to do an amendment to that document. Okay, question 48. We are trying to get our proposed CC&R revisions voted on now. This is our second attempt. What other options do we have if we don't get the vote we need this time? Well, I would say reach out to our firm and look at our cheat sheet. Amending CC&R is a 5-step plan. You really do need to have a strategy when you're amending your CC&R so you're successful. And you need to take feedback from your owners as to why they're voting no on this, if that's the case. So I think further evaluation needs to be made on this so that you can be successful on your amendments. I know that I recently saw a case where an association appealed to a Superior Court judge to amend something in their documents, and they were successful. So, I mean, obviously that could be a pivot here, but that was kind of an unusual circumstance. And my understanding of it is it was an unusual circumstance. So I would say reach out to our firm. We'll be happy to help you take a look at this. Okay, next question, number 49. Our association posts the meeting minutes from open meetings on an online portal accessible to all community members. Do we have to post the executive session meeting minutes on the portal also? Can a member request them? So executive session meeting minutes should never be on the portal, and owners cannot request them. Those are for the board's eyes only. Okay, next question, number 50. Whose responsibility is it to prepare and send out the agenda for meetings, the president or the secretary? In most cases, it's the president, but in some cases, the secretary does it. Just work together and decide what works best for your association. Question 51 from an owner. I submitted a request to be on the board for our upcoming elections. I never received a response. Another member asked to be put on the ballot, and he received a response. The president is constantly belittling me. Can he reject my request to be put on the ballot? He sent the email looking for volunteers. So no, if you requested to be on the ballot, your name should be on the ballot unless there's some factor that causes you to be ineligible to be on the board, like you're not an owner, or maybe there's a provision in your documents that says if you're delinquent, you can't be on the board. Those would be the only things. But you should receive a response letting you know that, hey, you can't be on the board because, I mean, it just sounds like it's a personality thing with the president. And I would ask for confirmation that they received your request to be on the board. That would be what I would do right now. Okay, next question, number 52. I've heard conflicting answers from various different people. Does ARS 33-1818, the right to regulate public roadways votes, apply only to parking, or does it include a planned community's right to regulate garbage bins being out for more than one day, portable basketball hoops in the road, etc.? Okay, let's see. It does say the association, I'm looking at the statute right now, 33-1818. It says an association has no authority over and shall not regulate any roadway for which CS ownership has been dedicated to or otherwise held by a governmental agency. So first question. So is your association's common area roads, are they dedicated to the city, town, or municipality for this law to apply to you, right? Then second question, are you a planned community? I guess here's what I would say. I think the garbage bins are a separate issue that aren't going to be covered by this. The portable basketball hoops, that is a little bit of an interesting question here. I would say that we still should be able to regulate that because we're regulating the owner's behavior, but it's kind of a gray area. This is a good question. I think, in my opinion, we should still be able to regulate these two, and that the roadways, it would be more like parking of RVs and boats and cars on the roadways. But this is an interesting question. I mean, no one's asked me this before. I think in theory, yes, I think we should still be able to say, no, you can't do this. And they shouldn't be able to just put those on the roadway. Even if we can't regulate it, you might want to check with your city, town, or municipality to see if they have any things that may cover these areas that you might be able to rely on. But at first glance, I would tell my clients to still continue, sending letters on those trash cans and basketball goals if people are putting them in the roads, if you don't opt to vote on this and continue regulating your roadways. Okay, next question, number 53. We just came under full management with a new management company. The management company claims they have to send monthly statements to all owners. Based upon the summary provided, we understand it to say only for HOAs over 50 units or not managed by a third party, and only for delinquent accounts, of which we have none. This particular management company states the opposite. So let's take a look at the statute. Okay, so the statute is 33-12-50-12, and it says, except for condominiums that have 50 units and that do not contract with a third party to perform management services. So it's and, it's not or. So the exception is condominiums that have fewer than 50 units and do not contract. So you do have to comply with this. So your management company is right on this. So the association has to provide a statement of account in lieu of periodic payment books to the unit owners with the same frequency that assessments are provided for in the declaration. So if you have monthly assessments, you're going to have to mail out those notices. The statement of account shall include the current account balance due and the immediate pending proceeding ledger history. If the association offers a statement by electronic means, a unit owner may opt to receive this statement electronically. The association may stop providing any further statement of account to an owner if collection activity begins by an attorney or a collection agency that is not acting as the association's managing agent. Okay. See, statement of account. Okay, so the bottom line is, yes, the management company, what they told you is correct. They have to send these monthly statements to all owners. They don't have to be delinquent. It's showing what's currently due under the current assessment and then any proceeding ledger history. Okay, question number 54. Let's see what information is required in paragraph 3 of the BOIR report for the CTA. The answer to this is the key information for beneficial owners would be the full legal name of the owners, the date of birth, the current residential or business street address, unique identifying number from an acceptable ID, and an image of the ID with the unique number. The definition of a beneficial owner is somebody who exercises substantial control over the company or who owns at least 25% of the company's ownership interests. At least one beneficial owner must be reported. It includes senior officers and those who have significant decision-making influence. Companies must keep this information up to date and accurate. And the summary covers kind of the essential requirements for Part 3 of the BOIR report. Some management company CEOs are filling in as this information under this paragraph 3. If the management company is refusing to do that, then the president usually steps into this role. Okay, that's it for today. Thank you so much, everybody. It's been a great 2024. Thank you for being with us for First Fridays throughout all of 2024 and for our virtual neighborhood services, virtual HOA academies. It's our pleasure to provide free information to all of you, and we're so appreciative of that opportunity. Next month, we're already going to be in 2025. We are going to be having our live virtual First Friday event. We're not going to be having it on January 3rd, which would be the first Friday in January. We're going to be having it on the second Friday of January, which is January 10th, because of the New Year's holiday being in the midweek. And so our firm's website is going to be updated with that information. So just know January, we'll be sending out reminders on our Mulcahy memo, but just know that our first Friday event in January will be the second Friday in January 10th at 9 a.m. We also have 2025 Virtual HOA Condo Academy class. Our first class of 2025 will take place on January 21st at 11 a.m. And you can visit our website for more details. Just in conclusion, I hope everybody has a great 2024. We appreciate the opportunity to work with all of you. We wish you a very happy holidays and Merry Christmas from everybody on my team at Mulcahy Law Firm to your boards and your management companies and to owners. So take care, everybody. Be safe over the holidays and have a wonderful holiday season. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.